Welcome back to the Hearse Chaser podcast show. This episode is entitled Words of the Will, Decoding Legal Lingo. I've had so many clients tell me how frustrating it is that they don't understand the terminology. They want to be precise. They want to explain things. They want to understand for themselves, but also to explain things to other folks. And so we're putting together definitions, the most common terms that you're going to hear in estate planning, probate, and elder law. And the hope is, if this is your first encounter, this is a great kind of summary of the different documents, so you don't have to walk into an attorney's office to be afraid. Use the right terminology, and it will certainly help you as you plan for your own estate. Welcome back to the Hearse Chaser podcast show.
You're listening to the Hearse Chaser podcast show. Here's your host, Stephen McClellan.
All right, here we are back at the Words of the Will, Decoding Legal Lingo. Every profession has its own terms, and we often use those terms to speak quicker, to be precise, to know exactly what we're talking about. And oftentimes when you're dealing with legal stuff, there's Latin that goes into it, and that can just confuse folks even more. So we'll talk a little bit about that, but the whole idea is to break it down where you can use the words, understand what they mean, and have confidence that you're saying the right words. So one of the first things I want to talk about is just the core documents. We'll talk about the documents that you will find. So one of them is a last will and testament. This is after death instruction manual for a judge. Let me say that again, for a judge. So people think, I have this will, and this will, in fact, I had a client this morning that they had a will reading. I've never really done a will reading in my career. Like, people sit around and read the documents, but I guess some attorneys like that, or they maybe it's a way to bring people in. I haven't done it in my practice, but the reading of the last will is not really a thing that has to be done, but that is what that is, a will. So a couple things to know is that a will doesn't avoid probate. Wills are just instructions to probate judge, I have 4 kids. I really just want to give it to 2 of them, and in this way. So it is not like you read this will and then families start passing things out. It has to be approved by a judge, looked at by a judge, filed with a death certificate, all these things when it comes to a will. Now, a trust is a very different type of document. And some people ask, well, what's the difference between an inter vivos trust and a testamentary trust? Okay, fair question. So an inter vivos is a fancy word for saying living, like you did it while you are alive. A testamentary trust is a trust that's created from your last will. And as I just said, the will gets filed with the judge and it starts probate. So a lot of times it is best to have a living trust because it avoids all that probate. So this is a huge point of distinction. Some people may say you need a trust, and you go in and you set up a testamentary trust. Well, I've seen a lot of frustration. I get frustrated because there are some attorneys, that's what they do. They say, hey, you should name your testamentary trust, your estate as the beneficiary on everything you own, like your life insurance, your retirement accounts, everything goes into your estate. And so when you die, then it can go into a trust, okay? And the trust can have separate pots of different money for different kids, okay? That testamentary trust it's a big red flag here, because the attorney makes more money the more money that's in an estate. So if you're setting up a testamentary trust, you're saying, look, I want it all to go to my will, through a judge, public record, 2 years or so, sitting in a court. That's what I want. Go for it. But my question would be, if you had an account that you like life insurance to go to 3 kids, why don't you simply name all 3 kids as a beneficiary, and when you die, it goes to those 3 kids? So I think that's quicker. Now, the response to that is, well, a testamentary trust is better than a beneficiary, because a testamentary trust can say things like, the money doesn't get distributed all at once. It's going to be spread out over time. There's some language if somebody is in bankruptcy, being sued, the testamentary trust can protect those assets. I say all that is fine and well and true, but why not do a revocable trust? So a revocable trust, that's a living trust that's done while before you die. So in that case, the life insurance goes into the revocable trust, the living trust, and so it avoids all kinds of probate. And I think what you have to be careful of, I think there's a place for testamentary trust. They were more common, I think, maybe 15, 20 years ago. They're more common, I think, with children, like young families. If they want to make sure that whatever anything goes to those kids, it would go through probate. It would take some time, but we're not so worried about time in that instance with the kids. And the language could say kids get the money at certain ages, maybe before they're 18, and so that's not bad. I don't have a problem. I don't have a problem with that analysis, but if you're in your 50s, 60s, and beyond, testamentary trust raises some questions that I would say, well, why that versus a living trust? So, when trust can be broken down, there's 2 types here. There's a revocable trust and an irrevocable trust. Those are the 2 primary trusts. It's helpful to think about their purpose. So a revocable is changeable. You can make changes to it. The irrevocable trust is designed to protect assets from a nursing home. So there's some caveats to changes that you can do. So you'd say, well, how do I know which one to choose? And I think that would be, I think, another podcast we've already done on that can kind of dive into revocable versus irrevocable trust. But the importance is making sure that you know what kind of trust that you're getting. And I prefer calling them a revocable trust instead of a living trust. What I'm telling you right now is a question that I get so many times. Well, okay, what's a living trust then? I know what a revocable trust. A living trust just means that you set up the trust before you die, as opposed to the testamentary trust that's created when you die. So hopefully that kind of explains the trust. And I would say that, generally speaking, people are coming to realize more and more how important a trust is and what it can do for the families, and how beneficiaries have some limitations, don't have as many protections. And when you really sit down and talk about what your goals are, what you want to accomplish, I think the trust probably marks off more of those goals than maybe a simple will. So I want to talk about advance directives. This is a healthcare document that says what you want in the event you become incapacitated. So as long as you can make your healthcare decisions, you're going to do that. But that advance directive, some people call them a living will. You can use either term. What you need to know from a practical standpoint is the living will is the more common of the 2 terms. If you do a Medicare checkup, like a wellness visit once a year, they will ask you, oh, do you have a living will? And as I understand it, I think this is true, that the provider who's asking you these questions, they're actually getting, I think they get upcharged somehow on that visit that they consulted with you about a living will. And it's very important in our state. One of the reasons why the physician and the staff will ask you, do you have a living will, is under our state law, a physician, if a living will is documented, a physician has to review it and say whether or not they can comply with it. If they don't want to comply with it, they have to transfer that care to a physician that will follow that. And if a physician does not follow that living will, advance directive, there are criminal charges that can be filed against a physician. I don't know that it's ever actually happened, but it's important to know that that does exist in at least our state law. Now, how does that differ from a power of attorney? Well, I want you to think of a power of attorney as really one of the most important documents. And the reason for that being is if you have a situation where you're unable to pay your bills, you are sick, or you're in the hospital, it's important to have somebody who can pay those bills. And that's what the power of attorney will do for you. Now, the power of attorney has a principal. That's you, the person that creates the power of attorney. And the person that has the authority is the agent. So you're not creating a lawyer out of drafting these documents. Okay, no one has to pass the bar to become a power of attorney. But those are the two roles, the principal and the agent. And there can be multiple agents. Typically, there's only one principal. I've never seen a power of attorney that was like a husband and wife power of attorney granting to a son. You don't see that. You see individual powers of attorney, but you can have multiple agents and you can have successor agents, which is very common. Husband and wife, the initial agent, initial is the one that can act presently, and then the successor is the backup.
Thank you for tuning in to the Hearse Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearse Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearse Chaser podcast show.
When you look at that power of attorney, some of them are springing, and you might see the term durable, okay? Let me talk about springing power of attorney first. So springing is, hey, this power of attorney is only good if I am incapacitated, as determined by a doctor. Now, I deal with this every single day and have seen so many different scenarios. And the thing that's interesting about capacity is it's not so black and white. It's not like, well, you're incapacitated and you will forever be incapacitated. There are good days and bad days, okay? And if someone has dementia, you know, they could have a season and an illness that they might possibly be more ill and need the power of attorney, and they might come out of it. So I don't particularly like powers of attorney that require a doctor to declare someone incapacitated. And I've seen one of the worst, I didn't like this, was it required not only a doctor, but a judge to declare someone incapacitated in order to use the power of attorney. So the whole premise behind a power of attorney is that you have the document so you don't have to get a guardianship, you don't have to deal with court. And I don't like that language. And that's very uncommon. You got to be cautious. You know, that's the newer attorneys, they're not using those documents. So, you know, if the attorney that you're working with, the documents look like they haven't been updated in 10 or 15 years, the font looks kind of funny, it looks kind of not put together very well, the attorney seems kind of disheveled, and, you know, that should, you know, caution you a little bit that maybe these documents, like if they're not ready, like when you come in, that would be a concern. But the power of attorney, I prefer the power of attorney to be effective immediately. And you want to read that because now then I don't have to worry about incapacity. I don't have to worry about, is this a good day or a bad day? Can I use this? Can I not use it? It's just effective immediately. Very common with husband and wives to have those set up that way. All right. Let's talk about executors versus trustees. And clients get these confused all the time. And I generally don't correct people because I understand what they're saying. I typically let them, I don't want to interrupt them and them forget what they're talking about. So in some of my ways, I will let them ask the question and then I will use the right word in the response. I do this with my children. Sometimes they'll use the wrong tense of a verb and it just hits you wrong, right? You just, I can't let that. I got to correct them. And then I'm like, no, I want my child to feel like they can express themselves. And so then I will repeat kind of what they said using the verb the right way. And I feel like that's pretty effective. I think my kids, like as soon as I say that, they instinctively want to rephrase the question. But I think it's good enough for them to hear. You can become, I think pedantic is the word, like really like laser focused on little things. That's not what attorneys are here for, is to, criticize people. Oh, you didn't use the right word, make them feel bad. Our job is to fully understand the question. So I don't jump on people if they make these distinct, they don't understand them. So, because I'm sure I've made mistakes, and everyone makes mistakes. I misspeak all the time when I'm talking to other professionals in other areas. We are all human. We cannot know it. Even I have probably made mistakes today talking about these terms, so don't feel bad. But an executor is someone named under a will. A trust has a trustee. Can a last will have a trustee? No. Can a trust have an executor? No. But what happens if there is no probate? Okay, there's no will and they need probate. Well, that would be an administrator. So you're administering an estate that does not have a will. So those are two different terms. You can just say the term personal representative and it covers both. Okay, that's a beautiful term. I like to just say personal representative of the estate or say executor of the estate. You wouldn't say executor of the trust. You wouldn't say that. You say trustee of the trust. So the trusts go together. Oh, what's a guardian? People ask a guardian. So a guardian is a court-appointed person who's in charge of another person. So oftentimes this is a child being named guardian for mom and dad. Okay, mom and dad in this scenario are sick, unable to handle their affairs, and they are called wards in our state. That's what our state uses. Other states have better terminology. Some people feel like that term ward is offensive, and I have like incapacitated person. I'm not making any judgment call. I'm just telling you what terms are used, right? So that's a guardian. Now, typically, a guardian can be a guardian of the estate or guardian of the person or both. So a guardian of the estate handles the finances, and the guardian of the person handles the health care. Now, if you have a power of attorney, you don't need to get a guardianship. A lot of times people will call my office and say, I need a guardianship for mom. And I said, okay, well, who's the power of attorney? Because typically if mom said, I want Sarah, the oldest, to be the power of attorney, typically that's who we want to talk to. Sarah would be the guardian, but if there's already if there's already a power of attorney, why get a guardianship? And I get frustrated. I see too many guardianships. That's a whole pet peeve of mine, when powers of attorney would be sufficient. As far as assets, so after mom and dad, people have died, here are some terms to know. Beneficiaries is the person receiving the goodies. Okay. An heir is the default person if you don't plan well. So each state has a default. If I die and I don't have a plan, I have heirs at law. Okay. And typically that looks like children and spouse. Couldn't tell you, but it's called the intestate statute. If that's the key one. I have to look it up all the time. when I'm like a third cousin or something calling me saying, well, who gets what? There's no will. Well, let's look at the intestate statute. Intestate means no will, right? We said testamentary trust is a last will and testament. Intestate means there is no will. We talked about the probate process. Probate is someone said it's a 4-letter word. It's not really a 4-letter word. Could be like that, but it's slow, it's public, painful. That's probably the best definition of that. Fiduciary is somebody who is responsible for managing someone else's affairs to their best interest. So guardians, they are fiduciaries. They cannot use money for their own benefit. They have to do it for other folks. In last couple terms, I think estate planning, probate, and elder law. Those are the 3 things we do. So estate planning is when you are setting up an estate plan before you die. Probate is when there's a will or there isn't a will, and assets have to go through the courts. And we could easily say probate and trust administration, because if there is a trust, still has to be administered, but that's the after death planning. And then there's elder law. That's the 3rd thing that we do. In elder law, the distinction between it and estate planning is estate planning primarily is concerned with what happens when you die. Elder law is, well, what if you get sick and you don't die? You need to be in a nursing home or assisted living. As an elder law attorney, it's a different approach. It's looking at things that could happen. And the big one is going into a nursing home, having a situation where you're, out of pocket $8,000 to $10,000. How do you protect those assets? So when you call a law firm, you say, I'm concerned about the nursing home, you're really looking for an elder law attorney, because many attorneys that do estate planning don't also do elder law. So those are very distinct. And if I break down elder law just a little bit more, there is proactive planning and there's crisis planning. All right. So elder law, you already know that's protecting assets from the nursing home. So proactive is when you're doing things before you go into a nursing home. And typically that's 5 years before. On the other hand, crisis planning is when there wasn't a plan, or maybe there was a plan that you have to undo and someone's in the nursing home presently. Okay. So that's kind of how they break down. And I think some of the other podcasts kind of go deeper into that. But knowing the terminology, if you're concerned about the nursing home, you're looking for an elder law attorney. And elder law attorneys also do the estate planning. There are elder law attorneys, and they do all the estate planning, but there are estate planning attorneys that don't do anything related to elder law. So these are just some of the terms. My staff said that I had to do this. They said, this is a good, people need to hear these terms. They need to hear them used. And hopefully this has helped decode the legal lingo. There's nothing worse than not knowing the language and having almost a minor in Spanish. When I did an immersion program in Mexico, it was very, very difficult. I knew some things and didn't know some things, and you just don't feel like you have full confidence. So I hope this has given you a little bit more confidence about what terms to use, and not only will help you, but help you as you communicate with an attorney, other family members, because even when life ends, there's the paperwork doesn't, and the communication about it still continues on. So thank you for joining us on another episode of the Hearse Chaser podcast show. I know you can't escape the hearse, but you can prepare for its arrival. Like us on Facebook, on YouTube, Spotify, subscribe. We look glad that you're along for the ride. If we ever can help, just reach out to us. Enjoy the rest of your day.
Hey, thanks for listening to the Hearse Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.